story to help somebody, that's what you'd say. Now Gary helped Lynn move. He was in the helpful friends circle. The state puts up the friends. They put those two charts of friends. Well, Gary goes in the Jessy and Jenny, actual helpful friends who did things like help her move her mother's things, run errands for her, visit her in the hospital. Those were that group of friends, her real friends, her real current friends. Sounds like Lynn varied friends from time to time. But remember when Gary was here and he talked about the phone call that he heard? He happened to be at Jenny Flowers' home, and Lynn's calling, and you heard testimony from people how Lynn would call, just talk, like to do that. And the phone was on speaker and he could hear her talking for an hour or longer. And what was one of the things that he told you he heard her say? She had 3 ways she wanted to commit suicide. Also at the scene, another issue is the rigor mortis. It's undisputed. When did Lynn die? When did she actually die? If the deputy medical examiner had taken a temperature of her, we might have a closer idea, but what we have that we can use is the rigor mortis and the state of it. And it's undisputed and unrebutted. Rigor mortis starts in the jaw, the face, and starts to move down to the arms. From there, it goes over the rest of the body, and your trunk of your body becomes gets rigor, moves to the large muscles of your legs, and they get rigor. But it hadn't gone to those spots on Lynn. It was at the beginning stages. The deputy medical examiner agreed with us that it completes within 6 to 8 hours. And she arrived at the scene at 6:10. Deputy medical examiner arrived at 6:10. She said it took her 30 minutes to look at the scene, to photograph, because a lot of the pictures that we've seen over the last 3 weeks were taken by the deputy medical examiner herself. She took them. So it took her time to look at the scene, look at the body, and so on. But her arrival was at 6:10. The 911 call was made right around 5 o'clock, a few minutes before. It took her a while. So rigor is increasing in that time. It's more than an hour, hour and a half even, from the time Jessy arrived at the home until she looks at the body. So it had not moved down to Lynn's trunk. It had not moved to her lower extremities. And that's consistent too, isn't it, with what Henry said about, Henry Spiller, about the drugs in her system and about how long had they been there. He said a couple hours. He used the phrase a couple hours. So what we can see by that, by the state of that testimony of how long the drugs are in her system and how far the rigor has progressed, that she's only dead a few hours. She died in the afternoon, not in the morning. I pointed out the medical legal investigation of death book by Spitz and Diaz, and deputy medical examiner didn't dispute that what was in there would be authoritative. Lynn was being seen by a lot of physicians. The state has tried to suggest throughout this trial that there was nothing wrong with her, or basically nothing wrong with her. That she was not disabled, not in bad shape. That's how they've presented the case to you, but it's really not true. And anyway, does it really matter objectively how somebody might perceive her? Does it more matter how Lynn saw herself? I think that's what really counts. If somebody is going to decide to exit, take their own life, then it's because of how they feel, right? It's not because of how you or me or anybody sees her medical history. It's how she feels about her life and her pain. And she was in pain. She saw herself as in a lot of pain. And we've got records from pain management that back in 2017, the pain interferes with sleep, with daily activities, and makes her feel frustrated. And at that time, she did the Owestry score and is 31 out of 50. And we introduced the Owestry disability score. And look at the things that a person rates themselves on. It's how intense the pain is, how intense it is to you, how your social life is. Do you have a good social life or not? How is your, sleeping, and how is your employment, and how is your friendships? And all of those things that you just fill it out, and you let them know how you're feeling about yourself. And apparently, she saw she filled out the answers. We don't know what they were, but however she filled them out, when it was graded, she came up with a 31. That's how Lynn saw her life, as a 31, which is almost completely disabled, really, as how she saw herself. And the pain interferes with her activities of daily living. It says she's had pain for a long time. Look at that. Osteoarthritis in her lower lumbar spine since 1991. Numbness, weakness in her legs bilaterally. Pain aggravated by her ADLs, activities of daily living. And on her urine screen from September 26, 17th, it's appropriate for alprazolam, but inappropriate for lamazepam. It's not prescribed to her. We'll repeat it another visit. Again, she's not taking the pills the way she's supposed to. She's taking them not as prescribed. And again, they're stopping the opioids. We're going to stop the opioids. And you heard, didn't you, throughout this trial, the dangers of benzos and opioids. And we know that. We know that. We did probably even need to have people tell us about it, because we know it from what we hear of overdose deaths, the dangers of it. But here, she's got inappropriate pills in her urine screens. She was breaking her hydrocodone in half so she could make them last longer. Some things are giving her some relief, and some are not, but she's got a lot of risks now, doesn't she? She's got risks of respiratory depression, mortality for taking opioids concurrently with the benzos. Her primary care physician and herself, this doctor, think it's important to stop one of the drugs. And again, we've got the osteoarthritis. The problems continue. And they got so bad, didn't they, that she's got so many drugs in her, and along with alcohol, that Lynn's been discharged from the practice, from her primary care's practice, because of non-compliance. And again, inappropriate for alcohol. The state at the beginning of the case, remember, asked their witness, Dr. B, whether there was any evidence in the record that Lynn had any problems with her eyes. No evidence. But it wasn't true. And I know it was painstaking as I was going through those, if we can remember back to day 1 or 2, as I was going through all those medical records with Dr. B, but there was a reason, because it wasn't true. And I thought it was important that this jury, that you ladies and gentlemen see, that In fact, she'd been complaining about dry eyes and eye pain for a long time. Well, those statements weren't factual. Again, she was offered the referral to a pain psychologist. She declines it. She declines nutrition services. She declines physical therapy. And record after record, if you want to see it, you can ask, maybe possibly we can send those back for you to look at. But again, after again, she's encouraged to exercise, to quit smoking, and to not mix these pain pills. But it isn't just at Advanced Pain Management, it's also at Aurora, another facility where she was seen, and we can see that she struggled with anxiety. And they had a discussion, didn't they, with the side effects of taking benzos and opioids and the risk of morbidity. And so that was a discussion. And her doctor says due to her pain, all she does is sit around and smoke, sometimes 3 packs per day. I think there's 20 cigarettes in a pack, that's 60 cigarettes in a day. Day after day, that's all she's doing. Has chest tightness because of it. She continues to complain of GI issues and can eat only very little. So she says, eating very little, yet she's gained 30 pounds since December. I don't know how that happens if you're not eating. Again, she comes in for medication management. They told her, I'm not going to increase the benzodiazepines that you're taking. As the dose increases, your side effects increase, and your age increases the side effects. She's now in her 60s. I'm going to try her on Lexapro, half a tablet. She got heart palpitations, and she has numerous risk factors. Heart disease, obesity, hyperlipidemia, for which she's refused statins, tobacco use, recommends stress test. Concerns. The doctor doesn't even list them because there's so many. Instead, she says she has complaints. Complaints are concerns which include numerous in capital letters with an exclamation point. The woman was a complainer. And I'm not here to bash Lynn, but this is just the person we're dealing with here. She was complaining. And notes such as she has depression or agoraphobia, fear of going out, or she appears older than her age, and psych. She's very argumentative. She seems to be depressed. She seems to be, talks about having nothing since her parents died a few years ago. Another note, I told her it's unsafe to take alprazolam and narco. High risk of cardiac death if she continues to take the Norco. I will not refill the alprazolam. I can't put my license at risk. That's how bad it had gotten. Can you imagine that in the record? Doctor's afraid of her own medical license. Lynn gets very mad at me and says I am the one who referred her to pain management. She wants some medication. She really needs to go see someone new for a therapist, but she won't do that. She's depressed. And again, the suggestion that there's no problems with her eyes is not true. December of 2017, she's at seeing Dr. Rogers, and there is a problem with eyes that is discussed. She uses artificial tears at least 4 times a day. So when the state starts their case and asks their witnesses if there's any indication that she's got eye problems, obviously the witness, Dr. B, didn't really take a close look at the records. It's just easy to say no, because they want it to be a death by tetrahydrozoline, right? That's the decision she made, and they're going to stick with it and not look at the entirety of the woman's medical history to see what's accurate or not. There's another note. This is a new doctor, Abdullah. Now she's discharged from her previous primary care physician clinic due to breaching the contract, pain management contract. She tested positive for other substances. She weaned herself off of Oxy, supposedly. She's an only adopted child with no extended family. She lives in a condo she bought and has a couple friends who come visit. She also was at Pro Health, and the main records we know from Pro Health is from her hospital stay from September 15th through September 28th, 2018. That's a long time. Hospital does not keep you there for, well, that looks like 13 days, unless you're not healthy. We know that from our personal experience. Now, the state suggested, didn't they, that Jessy was lying when she said that she brought Lynn pills, lied about a camera, lied about pills, but it was true because it was in the record, which we'll come to in a minute. When she came to the hospital, she was not a person that really looked like she wanted to keep living, because she signed a do not resuscitate. She didn't want chest compression, no shock, no intubation. She's made that decision. And that's when she first arrives on September 15th. That's how she felt. There's the medications sent to the pharmacy for storage. The patient's medications sent to the pharmacy for storage. It was true. When the information was asked by the state of their own witnesses of whether or not there's anything in the record to suggest that Jessy brought medication to Lynn, and they said, no, no, no. There it is. And who else told you but the neighbor? Remember when the neighbor came over or testified in court, Jean Tennell, and she also said that Lynn asked her to bring her medications, but she wouldn't do it because of the cameras. So if you don't even want to believe Jessy, certainly have no reason to discount what is said by the neighbor. Pro Health records, the diarrhea, the liquid stools, it's been going on for 4 years. This is not something recent, the suggestion that somehow Jessy's doing something recently that's causing this. 4 years. She did meet with palliative medicine, and they help patients and families dealing with serious, potentially life-limiting illnesses and to navigate their care. She seemed upset, refused to talk about doing what the GI was recommending, which is apparently a colonoscopy. But she's in the hospital for almost 2 weeks. There's something wrong with Lynn. She isn't in good health. She doesn't want to do what GI recommends. And frankly, if you remember, the testimony was that she would be released on the condition that she'd have a full-time caregiver. If not, the record said she was to go to a nursing home. Lynn didn't want to go to a nursing home. Lynn doesn't have full-time care. Another point. Remember, the witnesses were asked by the government, any indication that Lynn was needing a walker? No, none. Another thing that's not true. Because again, she began walking with a walker. It's in her medical record. It started before she came to the hospital, and there's a picture at the scene of the walker on the couch. She's got lots of past problems. Her medical history is significant. Don't let anyone tell you it wasn't. It was to her. So the state asked their witnesses after witness, remember, any indication that Lynn was disabled. They started out their presentation by suggesting that the money she was getting from the federal government was for old age Social Security. That's what they were testifying to until we got them to agree that the money she was getting was for Social Security disability, not for old age Social Security. And remember, there's no indication, the witnesses said, that she was getting any free things from the government. There's no indication she was on food share or food stamps or Quest, nothing at all. But the certified records were admitted that show that Lynn was in fact getting, and we introduced these, that she was getting free food as early as 2015, or 2015. Sorry, I'm just drawing a blank on my date. I think it goes back earlier than that. For years. Even she was getting it for years. So we've got a woman that the federal government has determined is disabled to the point that they're going to give her Social Security disability, and the state's giving her food share, which, and it was 2015, I think, when she got it even before 2015. Now, we did hear the state brought in about the other friends. And I have no doubt that they care about Lynn in some way. But the person really who was there day after day, day after day, day after day after day after day to care for Lynn and to watch movies with her and to go shopping, and Lynn gave her money, no doubt. It was Jessy. They brought in Corrine. I'll get to her in a second, but before her, what about Jim Kelleher? The state brings in Jim Kelleher, who wants to deliver a birthday present to her in September. Her birthday was in June. That's a very close friend, isn't it? Who's just thinking about giving a birthday present 3 months after your birthday. And we do know that as to Corrine Poza, who came in, she had a bit of a poor memory. And I can understand that after the passage of 5 years, our memories aren't as good as they were back when something happened. It's hard to remember precisely. It's hard to remember even 9 months later, 6 months later, sometimes even a week later. So I understand that 5 years have elapsed. But she denied, remember the discussion with her about the safety deposit box. And in the safety deposit box was supposed to be $50,000 that Lynn had put in there. And we asked Ms. Poza, isn't it true that you told police back when you were interviewed originally about this, that Lynn had told you she had taken that $50,000 out of the safety deposit box? And she said no. But through the questioning of Detective Hoppy, he was able to tell you that actually back when Ms. Poza was interviewed 4 or 5 years ago, that she did in fact tell him that Lynn told her that Lynn had taken the money out of the safety deposit box. It wasn't in there anymore. She took her own $50,000 out of it. And the state wanted you to think that Jessy did that she took $50,000 cash out of it. It was taken out by Lynn, who knows when. Also, on the stand, Ms. Poza says, oh, we're such good friends. Lynn and I were such good friends till the end, very good friends. But back 5 years ago, when she was interviewed, and this was verified by Detective Hoppy, when she was interviewed 5 years ago and asked how good a friend she was with Lynn, that time, right after Lynn died, she said, we used to be very good friends. Not so much the last couple of years. Not so much the last couple of years. This group of friends wasn't such good friends the last couple of years. Anthony, Well, Corrine said she last saw Lynn in February 2018. That's a lot of months for a very good friend. These are the cards that were brought into court, right? And submitted to the FBI lab, ultimately as known handwriting of Lynn Hernan. And Anthony Posa talked about these documents, and he compared these, and he also was talking about another document, wasn't he, in court, where he said, I know that document could not have been written by Lynn because two reasons. The two reasons were my mom's name, Corrine, is misspelled, and two, she used my mom's maiden name. Now, as to the second point, let's say if you've been friends with somebody for 30 years, we can all relate to people we've known since high school. We know them by their maiden names. People we've known for a long time, since they were single, we know them by their maiden names. We have them saved by their maiden names. I think of my high school friends by the maiden names. So there's nothing at all suspicious. In fact, it suggests that Lynn probably did write it, because what's the chance of Jessy, if that's the suggestion, Jessy knowing what Corrine Posa's maiden name was? But the other point he said was that she couldn't spell, she would never misspell my mom's first name. But then they brought in the cards, and her name is spelled differently in almost every card. If you look, Corrine, Corrine with an E, there's an I in that one. I mean, there's 1, 2, 3, 4 cards, and every one of them has Corrine spelled differently. Though Lynn couldn't spell first names, apparently. But to suggest, as Anthony did, that the document is not written by Lynn because Corrine is misspelled is contrary to what we know are known documents, because suppose the family brought these in and showed them. Of course, they also said, Corrine also said, did she not, that Lynn was always writing things at home. She always had her pad, she was writing wills, she was writing documents. That was something Lynn was known for. And she said there would be documents everywhere, here and there, all around the place. So that's something that Lynn did. That was Lynn. Writing new wills, writing obituaries, writing cards, writing letters, writing notes. That was Lynn. That's something she did, and most likely did even when she was in the hospital sitting there for almost 2 weeks. When Jean was brought in to court and said that, denied that she had said Lynn was suicidal, but we established it through the detectives that she was. Remember when the medical examiner was here and we introduced her own data, the medical examiner's own data, to show, does it not, that people do commit suicide. This is for Waukesha County. This were the years that she provided information on. And we have plenty of people in the age range of the 41 to 65 and above. 2020, there's 37 people in that 2 higher age ranges that committed suicide. And how do people commit suicide? You can see all the ways in Waukesha County that it's happened, and it's sad. We're sad that people ever feel that to that point that they that's what they want to do. But people do it. People do choose to exit. And we have any number of people that have inhalation type of deaths, suicidal deaths, where you ingest some substance. And here, when we ask for the breakdown of what types of products or pills that people are taking to kill themselves, we got this breakdown. And remember, Dr. B went through it and she marked how many were actually overdoses from benzols and opioids. very dangerous drugs. Lynn was thinking about her death. She wrote her own obituary. She'd been thinking about her death since at least 2016, because that's when this particular document appears to have been written and notarized by one of the bankers at BMO, who came in here and indicated that's her seal, that's her signature. She's the one who notarized this document. Misspelled Jessy's last name. She can't spell names. But Lynn wrote that. Jessy wrote that. She's not going to misspell her own name. Make no mistake about it, Dr. B is called this cause of death tetrahydrozoline poisoning, that and that alone. That's what she says the cause of death is. She's never had a tetrahydrozoline death. She has no experience with that at all. Zero. This is the inventory that was taken of all the pills at Lynn's home and what was prescribed and what remained. 0, 0, 0, 0, 0, 0, 1, 0. Lynn took a boatload of drugs. When the first test was requested from NMS Labs and it came back, it didn't even check for baclofen. How is it possible that you really paid attention, doctor, to what was at the home? There's bottles of baclofen here, and you don't ask for baclofen tests to be done. It's a deadly drug. Henry Spiller said to you, that's the bad boy. In this case, that was the bad boy. So she's got it. Yeah, she ran a lot of tests because, oops, I forgot to check for baclofen. Need to run it again. What were the drugs in her? Baclofen, cyclobenzapine, hydrocodone, alprazolam, nifedipine. Not fatal levels. The state says these therapeutic levels. Therapeutic levels? No.
She was well known to like drugs and alcohol. That never changed. Lynn grew up that way, and she stayed that way. Maybe the pills changed, or the alcohol changed, or the drug of choice, but that's what she did. So it's just, it's so frustrating sometimes. Just thinking of like how she was.
I'll tell you this: she didn't overdose on any kind of prescription medication.
Okay.
Everything was at therapeutic level.
Therapeutic level. No. Dr. B testified that Visine, which is the product we know with tetrahydrozoline in it, testified about it. We know it's been on the market since 1959. We didn't hear about any reported deaths. She says it's outlawed in France. That's not true. It's not outlawed in France. It's not approved. No one sought approval. It's not outlawed. It's being careful with our words, not trying to mislead you, ladies and gentlemen, of the jury in this case. There was no evidence presented that any company was denied approval of tetrahydrozoline or Visine in France. It's misleading, as was Dr. Kasinko's abstract. Misleading. She put statistics on there, statistical trickery. Well, maybe that's a little harsh on her. Maybe that might hurt a little bit to hear that, but that's how Henry described it. He is so experienced in this area of toxicology. He's peer-reviewed toxicology articles for other people that want to print them and have them published. He's the peer reviewer, one of them, not of his own, of course, and it wouldn't pass muster. And I understand that she's a younger scientist. I understand that she wants to find a novel subject to write about. I understand wanting to be recognized. But this is only an abstract. It's not even a written article, much less submitted for peer review, much less next step, go to be published in any kind of literature. Henry, on the other hand, has written and published at the Nobel level. I mean, we're talking over 200. A 44-page curriculum vitae, CV. These were the positive findings that came through, and look at what she has in her system. It's just incredible to see the number of drugs and the quantities of the drugs. And maybe one alone, fine. But the combination, deadly. Dr. Thomas said it was a polydrug overdose. Where does tetrahydrozoline rate in the dangerousness of the drugs, according to Henry Spiller, world-renowned expert in toxicology? At the bottom of the list. At the bottom of the list. Remember also Dr. Kacinko bringing in an article that in her rebuttal, she came back up for like a last rebuttal. She brings in some article that is from somebody she met at a conference. It's been cited twice. In other words, no one's citing that article. It's cited twice. It's not well received in the toxicology community because it's not being cited. Now, Henry Spiller is able to, with his decades of experience at working at national poison control centers, where he's doing real-time work with people in hospitals who are in for overdoses. And he is dealing with the doctors and the nurses and the hospitalists and the emergency room people, and he's trying to calculate what's going on and what's in their system. Remember, a girl says, I took 20 Tylenol, and he says, no way, didn't take 20. I know based upon the levels I'm seeing, it's 30 or 40, whatever the number was. He knows that, he does that. It's what he does to save people's lives. And he follows the patients, doesn't he? From the minute he gets the call from a hospital that somebody's on an overdose through their discharge or their death. He knows how to calculate how many pills. Nobody else knows how to do that that was in this trial. And he calculated that Lynn has 33 to 42 tablets. And it's higher than it was originally because other drugs were found. Because remember, there were pills in her belly, right, that were never tested. But he did the calculation, 33 to 42 pills. That is a boatload of pills, consistent with this boatload of pills, bottles, mostly empty, not all, found at the scene. And nobody's shoving 33 to 42 pills down somebody's throat. No way. Remember, Lynn was a savvy pill taker. She'd been taking pills and all sorts of pills for a long time. No one's going to trick her on her pills. Lynn knows what she's doing. She's been taking them for years. And there's no indication in the record that anything was forced, because I specifically asked if there's any sign of injury to a mouth, to a throat, a trachea, anything to suggest that there's any kind of forced ingestion, and there isn't. There is not. She took them herself because she wanted to. And as to those other cases that were cited by Dr. Kacinko, for example, Henry Spiller actually calculated the amount of tetrahydrozoline that was in that child at peak. 115 ng per milliliter. Now there's a scarcity of cases. You think that that we should be able to come in here and show you case after case after case of tetrahydrozoline and what levels should be, but there aren't. If they were out there, we would have them here for you to see. But there is that case where he's able to do the calculation. 115, Lynn was 160. 115 had a little bit of problems, a little bit of respiratory depression, used a little mask of oxygen on the child, rapid improvement. That's what 115 ng per ml does to a little child. And he made a point to let you all know that children are not little adults. The effects on a child of any kind of drug are going to be much higher, they're stronger than that on an adult. Yeah, the five pills. 5 pills found in Lynn that the medical examiner never tested. And in fact, didn't know what they were, never bothered to figure out what they were until we met with her and pointed out the number 30 on one of them, and couldn't that be nifedipine? And between that date and when she came into court, she agreed, she looked it up to see if we were right, which we were. She said, you were right. None of this was taken into consideration by her at all. Never tested them. What kind of medical examiner, when you're talking about a poisoning, so fixated on the THC? Why did she fixate on it? She'd never seen it before. I agree. Probably, if she says that, it's probably true. It's Sherry Kasinko from NMS Labs who was all excited, wasn't she, about, at that time, about this high level of THC, because she's wanting to do this article. She's got an abstract. She's getting her lab automatically tests for THC, and now she's got this case with a high level. She wants to be recognized. She wants to cite it, so she gives a suggestion to Dr. B that this is fatal. This is what killed her. Because what other evidence is there of it? There's not. It's not true. There's a lot of drugs in her system. Dr. Thomas told you that. Mr. Spiller told you that. You can see the charts for yourself. It is just an incredible number of pills. And Lynn wasn't healthy. Dr. Thomas was careful to tell all of you about the other problems with Lynn, like her fatty liver disease, which shows the alcoholism, the stenosis that she would have thought if there wasn't anything with drugs, that there would have been a heart issue that might have killed her. Her obesity, she's 251 pounds at death. How did she gain? You know, from earlier records, where we see 50, 100 pounds. This is incredible weight gain. She's type 2 diabetic, the pulmonary disease, the interstitial myocarditis, the hypertension. The woman had a lot of health problems. And Jim Berg was in court to talk about her finances too. He said that she was broke. She knew she was broke, tying into financial things. This wasn't news to her. But before I leave on the medical part of it, remember Henry Spiller said that he did write an article about tetrahydrozoline and its effect in sexual assaults. And he said he wrote it and did the research on it because he wanted the FBI to adopt this as one of the standard tests that they use when rape kits are done. And of course, when the FBI makes recommendations, you don't have, a city or a state is free to reject or accept them. But his goal was to get the FBI to recognize that THC to make the testing for THC a part of the recommended national protocol, I think is what he said, when they're testing blood or urine. And that's probably, isn't it, why NMS Labs ultimately put the testing for tetrahydrozoline in their regular testing regimen, because they get all blood or urine to test in all sorts of cases. People use the lab, not just because somebody died, but for any reason, including you could send urine for a rape test. And so they accepted that recommendation, it seems, and put that as part of their regular testing. So when it comes to first-degree intentional homicide, the state has not proven it. They have the burden to prove it beyond a reasonable doubt. They didn't do that. They failed. Such a serious charge. Defendants aren't required to prove their innocence. The law presumes every person charged with a commission of an offense to be innocent. The burden of establishing every fact is on the state. Ladies and gentlemen, if you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so. You must do so. Return a verdict of not guilty. And as to the homicide, that's exactly what we have here, an absolutely reasonable hypothesis of the defendant's innocence, and you must return a verdict of not guilty if you agree with that. There are other words in jury instructions, such as you should, but here this one is must. It's must. Of course, the last part of the instruction, and what no doubt the state will indicate to you when they get back up here, I don't get a second turn. They'll say, it's your duty to give the defendant the benefit of every reasonable doubt, but you're not to search for doubt, you're to search for the truth. But by their own admission, all we have here is circumstantial evidence. There is really, that's all it is. It's a circumstantial evidence case. I don't know, it's not easy to search when you're missing so much information, like testing of pills and saving of evidence at a scene. And I did, and I hope you can see my chart, because I think it's important to look at what does that even mean, reasonable doubt or proof beyond a reasonable doubt? It's such a legal term. It's hard to understand it. But you can look at this chart and kind of get an idea. If there's no trace of evidence, of course, that would be not guilty. But even if there's any evidence at all, a scintilla of evidence, that would require a not guilty. If you have a reasonable suspicion, which should be based on specific or particular facts or reasons, it's not based on a hunch or a guess, so it's more than a hunch or a guess. Call that a reasonable suspicion, not guilty. What about if you got probable cause? You hear that all the time, even if you're watching TV. We got probable cause, we're going to get a warrant, or probable cause for this or that. Reasonable and trustworthy information that a particular person has committed a particular crime. What if we have that? If you think that there's that here, that's a not guilty. Well, let's go even higher on the chart and think about, what if we've got the greater weight or amount of evidence? In other words, there's a greater weight of the state's evidence compared to the defense evidence. If you felt that, which I don't, based upon Dr. Thomas and Henry Spiller, but if you felt it, it still requires a not guilty, because that's only a preponderance of the evidence. That is inadequate to convict. Even if you have a firm belief that the allegations are true, in other words, clear and convincing evidence, you must vote not guilty. That requires not guilty. And if there's any reasonable doubt, it's not guilty. Only if the state presented evidence that went on that ladder, those stairs, all the way up here, would you be able to vote guilty? And I submit that as to the first degree, intentional homicide, the intentional taking of Lynn Hernan's life, that they have not proven their case. I do want to talk to you about the financial things. So, the state suggests that Jessy was taking all this money from Lynn. Actually, Lynn and Jessy were close, and Lynn gave Jessy money all the time because she wanted to. And Lynn spent a lot of money before Jessy was even on the scene. We took the total account balances, and you can look at it if you want to dig through the financial records. We've added things up. And you can see that in 2014, she started with $346,000. And by January 15 of 2015, she's down to $305,000. And by January of 2016, we have her down to $272,000. And the first check that was written to Jessy, ladies and gentlemen, was in July of 2016. And this continues on for the rest of the accounting. But remember, the first checks to Jessy are in July of 2016, and FBI, who we brought in here, again, the state did not bring in the FBI. They didn't want you to hear from the FBI. The checks written to Jessy, she rated them as a common source. Support for common source. Now, I know that this chart is not the easiest chart to understand. I had to have it hammered in my head again and again. So, of course, if they never say they're certain. Apparently, the FBI doesn't do that. But we've got inconclusive in the middle. We're not sure. As we move to the right, it's more likely that the person wrote it, and as it moved to the left, it's more likely the person didn't write it. That's really how this goes. So all the checks that were written to Jessy, the name, Jessy Kurczewski, not always spelled correctly, and the numerals were support for common source for Lynn. That Lynn likely wrote the Jessy's name and the amounts. As to the signature, the Lynn Hernan signature, because of the lack of clarity in documents that she had at her disposal, she was inconclusive. That isn't a support for a different source. It's inconclusive. And I think there was a suggestion during this trial, as I recall, somebody suggesting, well, if Lynn had duplicate checks, wouldn't Jessy be able to duplicate her signature from the duplicate check? Well, first of all, that's a if. There's nothing in this record that Lynn had duplicate checks. So that would be a guess. We're not here for guessing. If Lynn had duplicate checks, bring in somebody from the bank, from the deluxe check ordering company. The state should do that, right? And say that Lynn had duplicate checks. There's nothing in this record that she had. But second point, we know, don't we, from our duplicate checks that the signature is blacked out. They've done that for years on duplicate checks just for the purpose that if somebody steals your checkbook or you misplace it, you lose it, that people aren't going to see your signature. So that's just ridiculous. Now we have known writing of Lynn. This was known writing of Lynn. Lynn liked to spend money. She liked to give money away. She liked to spend beyond her means. She liked to give away beyond her means. That's what she did. And giving money to Jessy made her happy. Jessy was like her daughter. Jessy was the person who was there all the time, and Jessy probably give her a hard luck story. I need money for this and money for that, but Lynn was happy to give it to her. The crime requires that it be without her consent. There's no evidence here that Lynn didn't consent. Lynn, in fact, gave the money willingly to Jessy. But she liked to spend money, and she liked to give it away. As I told you, check item numbers 47 through 56 and 58 through 83. Those were support for the writing being of Lynn's. She wrote the body of those checks. And the two in between that, I should point out, because you might be wondering, well, where's 50 or 67? I think there's 57. They were confirmed as Lynn's signature. Now look at how her spending dramatically increased. So here we've got Lynn going to the hospital. She got $19,000. She has a discussion on September 21st with palliative care, and spend. Once she knows that she has to either go in a nursing home, which she doesn't want to do, she's made a decision. And it's spent and spending. And that's when the ATM withdrawals began. And Lynn liked to have cash. Of course, she sent Jessy to do things for her. Lynn's discharged from the hospital, and she's down quite a bit of money, and is all after her discussion with hospital people about the palliative care, having to go into a nursing home, or having full-time care at her home. Withdrawal. Okay, now think about the two loans you heard about in this trial. You heard that Lynn applied for a loan first with her primary bank, which is BMO, B-M-O Harris. And there, if you looked at the documents carefully, she did exaggerate her income. It was exaggerated about 50%. She did note on those applications exactly what she had in the bank, and the application was done face to face. In other words, she was there at the bank doing the application, and she put down how much money she had in her bank account, and it was under $20,000. The suggestion has been made that Lynn was being taken advantage of and had no idea of her finances. False. She knew. She put it on her loan application. Now that was denied. So by increasing her income by 50%, she doesn't get the loan. So they together decide to make the application for Goldman Sachs. Goldman Sachs, they put up its income of $100,000. It's obviously poor underwriting, never looked into anything, but they accepted the documents and they gave the loan, they approved it. And on the day of the disbursement, the key thing is, Jessy added Lynn to her Wells Fargo account. She was added. And as to switching the names and adding her to the account, that was done in person too. We brought in the man that did that form with Lynn and Jessy at the bank, and he told you, you'd be there in person in front of him with identification to prove who they are. Not only that, but he's so careful to make sure that people are not being taken advantage of, that both the customer and the, both people, both customers before him are not being taken advantage of, that are in a good mental state, that they know what they're doing, and that in fact, we heard that all the banks do that. That's part of protocol. They just make sure that they don't see anything, that somebody isn't nudging somebody or signing for them or whispering and telling them what to do. So they did go for a loan, and there were obviously falsities told about Lynn's income of $100,000, but she wanted the money because by the time that February of 2018 rolled around, she didn't have much money in the bank. She just applied for the loan at BMO, and she had listed her assets at under $20,000. So Lynn was well aware in February 2018 that she only had $20,000. As to the theft from Lynn during her life, the state has failed to prove it. The record before us shows that Lynn gave Jessy the money willingly. She had no one else to give her money to. You might question it if somebody has heirs that are alive, like children, grandchildren, that you might want to leave your money to, but Lynn did not. She wanted Jessy to have it. She knows she's going out. She's giving it to Jessy. It is a lot of money. It's a tremendous amount of money. But just because it's a lot of money doesn't mean that Lynn didn't approve of it. And in fact, the evidence suggests she did. Jessy was the person that was there. No one else really knew knew Lynn like Jessy. She knew her. They're the ones that spent time every day, twice a day, together. And Lynn made a decision. She made a decision that she was going to exit. And she did that on October 3rd, once Jessy had left the home. We know it was then because of how long the body was deceased. The body was not dead in the morning. The rigor would have spread. That's just false. She put on her father's dog tags. That's a sentimental thing to do. That's when you're thinking about going to another place to be with your loved ones. I'm going to join her father, the person that she loved so much. She put on his dog tags.
And I don't mean that in a mean way, I mean it truthfully. She did a lot for me. So the fact of her being dead would do what for me?
Well, that's kind of coming up to overtake the assets. She has more credit debt than she has money.
Yeah, that's what I'm saying.
So the money's running out.
Yeah. So, but I don't get what you mean by that. Yeah, they were. I don't understand what you're saying.
The fact is she paid you $200,000 over the last 2 years.
Mm-hmm.
You're you are handling the money. You are on the signer on the accounts. You are running the show.
Yeah.
You are handling the credit card stuff.
Mm-hmm.
You know what's going on financially with her.
Mm-hmm.
The money is going to be gone here shortly.
So I would kill her because of that?
People do weird things.
Why would I kill her for money?
I mean, it's
my family.
I tend to think that you didn't, when you say kill her, I don't think you killed her. I think she was sick, and she didn't want to, she was done, and she wanted to finish her life, and she needed help.
And even if you think, as the detective did, that that's what Jessy did, that is not a first-degree intentional homicide, which is what is charged here. Look at the elements of the crime, that is not it. Even the detective thought it. As to count 2, the state has not proven beyond a reasonable doubt that Lynn did not consent to giving Jessy that money. And in fact, she did consent. And remember, if you can reconcile the evidence on count 2, the theft while Lynn was alive, with any reasonable hypothesis consistent with Jessy's innocence, you must do so. You must do so and return a verdict of not guilty. As to count 3, which is the theft from the estate, really the only comment I would make to you, ladies and gentlemen, as you heard during the case, the estate's not even closed. The estate is still open. When you go to the jury room and you deliberate and you look at all this evidence, and if you want to see something, send a note. We'll send it if we can. I ask you to return verdicts of not guilty. The state has not proven their case. The only true and correct verdicts are not guilty. And thank you.
Thank you. While you take those down, we'll just stand for a little bit. The state does have an opportunity to offer brief rebuttal, so we'll hear from that and then the final instructions. Just a note to all the people in the gallery, no one should have food, gum, or drinks. So if you have any of those, please step out and get rid of them. Thank you. All right, thank you. Have a seat. Attorney Nicolai, when you're ready.
Thank you, Judge. Ladies and gentlemen, because we have the burden of proof, I get to address you one more time. And the video you were left with was Jessy Kurczewski asking the detectives, why in the world would I have any reason to kill Lynn Hernan if all of her money is gone? I submit to you there was 87,000 reasons to do that, because that's the amount of theft that Ms. Kurczewski has taken from the estate in this case. This is supposed to be a search for the truth. And what has happened is that it has become a full-blown attack on Lynn Hernan. I want you to think about some of the things that you've heard said about this woman. And then ask yourself, why does that matter? She's an alcoholic. She's an angry drunk. There's bottles of alcohol at the house. The intent is to mislead you. Lynn Hernan had no ethanol on board at the time of her death. Lynn Hernan was not a bad person. She was a complainer. She smoked 60 cigarettes a day. She needs to exercise. She was 251 pounds at death and bad at spelling. Why do those things matter to you? Why were those things presented to you over and over and over again in this case? I submit to you, the intent was to mislead you. The intent was to shift your focus from the truth, which is what you are to be searching for. If Lynn Hernan taking her own life was such a reasonable hypothesis, consistent with the defendant's innocence, then why did she have to lie about it? I submit to you, ladies and gentlemen, that the reason that everyone at the scene thought this was a suicide is because that was exactly Ms. Kurczewski's intent that day. And it worked for a period of time until the toxicology came back. Is it really so surprising that detectives on that scene weren't taking empty water bottles with them? Do you think maybe what was collected would have changed had a witness come up to them and said, she's been drinking Visine for months. She's trying to kill herself. The intent was to mislead. Certain pills that she couldn't swallow, she had to crush them. That is nowhere in the medical records. Ms. Kurczewski told Detective Hoppy that she brought meds into the hospital and told staff, I gave all these meds to Lynn, she's suicidal, and that staff took those away and put a camera in there because of that. That's a lie. That is nowhere in the medical records. You were asked if Dr. Bedritsky thought this scene was staged. Why didn't she do something right away the next day at autopsy? Oh my gosh, the scene was staged. I have to do something. She did. She collected all that powder. The first time she'd ever done that, she collected it and sent it to be tested. You were asked why would Ms. Kurczewski leave these expensive bracelets behind? You know who got those, though, because we showed you. Very quickly after, Ms. Kurczewski goes and pawns those items, lying to the pawn store, saying she's owned them for months and months, and takes the cash that they're worth. Oh, she got those bracelets. Was there $50,000 in a safety deposit box or at Lynn's house? The thing we know about that is that money was supposed to go to Anthony, and he sure didn't get it. I submit to you, ladies and gentlemen, when you consider the mapping evidence in this case, and you see Ms. Kurczewski go back to Lynn Hernan's house that night on October 3rd, after everyone's gone, and the next day on October 4th, accessing that lockbox, consider that timeline. I have no doubt Ms. Kurczewski knew that cash was gone when she talked about the lockbox with Detective Hoppy, but that's not why she brought it up. She brought it up because she alleged there's all kind of exculpatory stuff in there that Lynn saved. I'm suicidal and recordings that I'm suicidal, it's all in there. She knew there wasn't anything in that lockbox, and that's why it's significant for you to consider. You've been now told that Gary Verdon is this really honest, upstanding guy who listened to a woman go on and on for an hour and a half about killing herself and didn't do a thing. A man who told you with a straight face that he remembered a bottle of eye drops in Lynn Hernan's garbage can because he had never seen them at anyone else's house in their garbage. That makes absolutely no sense, and you need to weigh his credibility when you consider whether anything he said is correct. The same that you have to consider evidence as it was admitted into the record and not what Attorney Kukler wants it to be. Gene Tannell did not tell you Lynn Hernan was suicidal. No detective told you that. Attorney Kukler's comments are not evidence. Henry Spiller did not convince Dr. Kasinko to start testing for tetrahydrozoline at the lab. The spending that you were just shown in the blue charts absolutely matches what we proved to you in this case, that it changes drastically in 2016. Attorney Kukler says, we didn't want you to hear from the FBI. What the FBI was able to tell you in this case was that someone could have written something, but also maybe not. That's the extent. Attorney Kukler told you, well, the FBI never makes conclusions. Well, they do. They do. It was on the right side of the spectrum, and it's called source identification. I want you to think back to evidence that you've seen in this case of the one person who is very acutely aware of creating fraudulent documents that are very convincing. And I want you to recall that Ms. Kurczewski told a roommate that she messed with that handwriting process anyway. So you're right, the state didn't think that that was important for you to hear in this case. Dr. Budritsky is not going to make an important determination like the cause of death in 14 hours. Dr. Thomas did. Dr. Thomas, someone the defendant hired and paid to be here and tell you that. But she didn't tell you it was a suicide either. Dr. Thomas certainly didn't have the benefit of all the interviews that you've seen. Dr. Kacinko testified and showed you that abstract because 3 weeks ago you were told by that team that you can't die from tetrahydrozoline. And that is not true. That is the value that Dr. Kacinko has to this case. She has her own data and her own lab to know that that claim is irresponsible and not true. Who didn't take a look at medical records in this case before offering a pretty serious accusation? Mr. Spiller, the graduate of a now defunct university with no doctorate degree, who told you that it's real important when you're making calculations to know about genetic or disease issues that would affect metabolism, had no idea that there was any issues with Ms. Hernan's liver. Dr. Thomas said, oh yeah, she did, and that would be real important to know. Nonetheless, he got up there and told you handfuls of pills that Lynn Hernan had. Why? Why was that information presented to you? Because I trust that you all have comprehended by this point that the things in someone's system affecting them at any given time are the levels in the blood. And that undigested, unmetabolized things in someone's stomach has no bearing. That's why Mr. Spiller said that medical examiners around the nation are not calling him and asking him to do these calculations for them. They know what affected someone because they have the tox in the blood. So I again ask you to consider, why were you presented that information? I hope it doesn't mislead you. I hope it doesn't shift your focus. Because, ladies and gentlemen, dry eyes didn't kill Lynn Hernan, back pain didn't kill Lynn Hernan. And I will mention this very briefly, because the palliative care discussion during this case has taken up more of your time than the actual consult did in the hospital, which was 30 minutes. Look at that record. It does not say what Attorney Kukler wants you to think it says. Attorney Kukler got up here and...
I'm going to object to the constant reference to Attorney Kukler.
Overruled. These are closing arguments.
Attorney Kukler got up here and showed you a picture from Lynn Hernan's body of dog tags and told you that those mean something and that's why she put those on, so she'd have them on when she got found. But no pants or underwear? Think about that for a second. You're making this decision. You know that someone's going to find you, and you're not going to put pants and underwear on? That makes zero sense. Detective Hoppy told Ms. Kurczewski during the interview that, I think you found the perfect victim. She had no family, you isolated her, and she had money. This group of friends who supported Lynn and loved her, that didn't see her, when Miss Kurczewski entered the picture as often? Why was that? Why didn't Lynn see the Anthonys and the Coreens? Absolutely, she wasn't feeling good, and no one could figure it out. But ultimately, ladies and gentlemen, to believe that this was a suicide, you would have to believe that by the most cosmic intervention in the entire world, it happened at the exact point in time when Miss Kurczewski maximized the amount of money that she made on this whole ordeal. I want you to think critically, and I believe once you have, you'll return guilty verdicts in this case. Thank you.
Thank you. I need to see the attorneys just for a moment. You all can stand.
All rise.
Thank you. Be seated. Now, members of the jury, the duties of counsel and the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Jessy Kurczewski. Count 1. One reading, we the jury find the defendant, Jessy Kurczewski, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Jessy Kurczewski, guilty of first-degree intentional homicide as charged in count 1 of the information. Count 2, we the jury find the defendant, Jessy Kurczewski, not guilty of intentional transfer of movable property having a value that exceeds $100,000 as charged in count 2 of the information. Hold on. Every now and again, we find a little mistake. So, because our verdict forms read a little different. So, I'm going to do that as to count 2. One reading, the jury find the defendant, Jessy Kurczewski, not guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. Another reading, we the jury find the defendant, Jessy Kurczewski, guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. If you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $100,000? Count 3. One reading, we the jury find the defendant, Jessy Kurczewski, not guilty of theft of movable property having a value greater than $10,000 but does not exceed $100,000 as charged in count 3 of the information. Another reading, we the jury find the defendant, Jessy Kurczewski, guilty of theft of movable property having a value greater than $10,000 but does not exceed $100,000 as charged in count 3 of the information. If you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $10,000? It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached, of course, as to each count. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Madam Clerk, at this time, please swear in the officer.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I will.
All right, for the record, both of our jury bailiffs were sworn. All right, as you can see, I pulled out the tumbler. It has the information for each juror. I will give it a good spin. All right. First juror will be an alternate and not initially or until perhaps not ever deliberate as juror number 28. All right, the second juror, number 13. And the third, number 19. Now, we will have you in a separate jury room where you will wait. You will not be able to discuss the case amongst yourselves, those who are the alternates. I'm not going to take away your electronics or anything like that. The same admonition that I've given you throughout this case remains. You may not discuss this case with anyone. You can't do any research. Don't review any newspaper reports or news reports. And if something were to happen to one of the other jurors during deliberations, then I would obviously have a conference with the attorneys and we'd discuss how to proceed next. I know that can be a little bit of a letdown, and we so appreciate all your time and attention here. You'll all be excused. I know that lunch was ordered, and Jen and Ken will figure out all of that, but all rise for the jury, please. My new page is in here, right? Is that what it is? Very good, Jen. No, that's fine. All right, for the record, Madam Reporter, it's 12:21. And for your record, Madam Clerk. Just be seated for one moment. I do want to put that sidebar on the record. I informed the attorneys at sidebar. There was just a little bit of a snafu. Normally, I have the CCAP application, do the randomized listing. Unfortunately, when that was done, we had a little bit, I guess, lost in translation about number 28, and believe it or not, it will not let you redo it. And so we brought the tumbler out, and then by agreement of the parties, we agreed that 28 would be the first number that I read, and that is what I did. Anything either side wants to add to that sidebar from the state,
No, thank you.
from the defense?
No, thank you.
All right, as you know, we remain open while the jury is deliberating. For the attorneys, if you choose to leave, just please, I think you've already given Madam Clerk the best contact number. My intent would be to let the jury deliberate as long today as they are comfortable doing, and if that does not result in a verdict, send them home, bring them back. Obviously, we'll cross that bridge if and when, but if they do receive or when they reach verdicts, then I will give probably about a half an hour to 45 minutes to make sure everyone can assemble back here. If there's a need for me to go a little bit longer than that, for whatever reason, if there's a family member that's a little bit farther away, just let me know and we'll work on that, okay? Otherwise, we are in recess. Thank you, everyone. Stephen, audio is on. You can look at the question and the answer. I know we're waiting for Attorney Kukler, but at least start that. All right, I'll just go on the record. There's one question. I know we don't have Attorney Kukler, but all other appearances are the same. Juror number 24 is our four-person. What is the purpose of the financial question for count 2 and count 3 that follows the if, quote, guilty, quote, verdict listing? And my proposed answer is as follows. Answer the question only if you find the defendant guilty. Any purpose of doing so are matters for the court alone to decide. And I've shown that to the attorneys, and Attorney Kukler's walking in, but for the record, Attorney Nicolai, do you agree with the court's response?
Yes.
Attorney Galaviz?
Yes.
All right. We scan everything in. You'll have it shortly. You can give one down, give it to. We are in recess. We'll have a copy for the parties momentarily. Are back on the record. The jury at 2:58 p.m. Did have another question. May we please have exhibit number 98, 118, 117, 134, 7 through 20, 130, 131, 23 through 32. And I went through Madam Clerk's lovely exhibit list, highlighted it, showed that to the parties, and then Madam Clerk pulled all the exhibits, and the parties have had an opportunity to review them. Any objections sending all of this back to the jury from the state?
No.
From the defense?
No.
All right, I will simply write C attached. Actually, I'm gonna write all exhibits are attached. All requested exhibits. Okay, we're in recess. We'll let you know when we have the next communication from the jury.
Thank you.
You're welcome.
Oh, this might be for sale.
Well, right, but if it's a phrase. Did you love your phone? Do you know what a head note it was in?
Head note 12 damages. And 13 practically certain. Here, the quote is, practically certain it must be more than reasonably probable or likely. It must approach being inevitable. For example, practically certain that shouting fire in a crowded theater will cause panic. It is not practically certain, but very likely that the New York Yankees will go to the next World Series next year.
Yeah, let me see what it says.
It's under 13,
Yep, I'm there.
page 881.
881, okay, got it. Looks like we got Teresa. All right, great. All right, good evening, everyone. We are back on the record. You're good. Appearances are as they were before at 5:34. The jury had a question, and obviously we needed to assemble everyone. I did have a copy of the question printed off and placed on each counsel's table so that you would have a little bit of a head start, if you will, to look at the question and provide input to the court. But the question is as follows: may we please have a definition and elaboration on the term, quote, practically certain, quote, listed in the second element under count 1. And of course, count 1 being the homicide charge. The two elements that have to be proven are, 1, the defendant caused the death of Lynn Hernan. There's a definition of cause that's provided right in the jury instruction. And then the second element is the defendant acted with the intent to kill Lynn Hernan. There's a definition of intent to kill, but it's that definition that includes the phrase, or was aware that her conduct was practically certain to cause the death of another human being. And so that is the question. Did a very brief search with my law clerk. We're finding, just very briefly, a federal case interpreting some Wisconsin law, but it's a civil case. I don't know if either of the parties have had an opportunity to find anything that's helpful in this situation, or if there's any particular requests on how the court addresses this with the jury. Anything from the state?
Judge, the only thing we've been able to find in relatively short order is jury instruction 923B, and specifically in the comments, I believe under comment 1, there's at least an elaboration part where it gives an example of what practically certain is under, as far as I can tell, what is sort of a generic arson situation. But that's what we've come up with in the last 5 minutes or so. As far as the juror's request for elaboration, I don't think it's got a solid definition provided in that comment section, but at least has an example of what the legal term practically certain means.
Can I have that number once again?
Sure, it's 923B under the criminal jury instructions.
How about from the defense?
Yes, we also took a look at 923B. I think in this particular case that the answer that should go back to the jury is you should rely on the instructions as they've been given to you. I'm not asking that that long form be given. It wasn't given. And I don't want to change the definition and the instruction midstream. Court gave the shorter instruction. That's the longer instruction that they're talking about there. I think that the jury should just rely upon what they've been given.
All right, so I I don't have 923 at my fingertips. It's not coming up in my normal search that I'm able to do on Word. I only have one of my volumes, so I will need to go grab my other volume from upstairs so I can review that. Let me just tell you where it is. Can you get, make sure you take this?
You could email it to
Too,
you.
if you'd
Oh,
like.
that'd be great.
Yeah. I'll have you do it then. Okay. But we could do it as well. We've got it right here.
Or you could just email it to her saying
Okay. Great. To the judge.
Yeah, and it should be, I know, but it should be, it's just in case your key's being, because mine's on the back. Yeah, that's what that is. The case that my clerk Ryan was able to find is a federal case addressing Wisconsin law. Looks like it was a decision by Judge Randa, Boomsma v. Star Transport, Inc., 202 F Sup 2nd, 869. Let me give that to you again. 202 F Sup, S-U-P-P, 2nd, 869.
So just for the record, we've sent that to you directly with the defense copied on the email.
All right, thank you.
Back on the internet.
I'll let you know when it comes in. It's an email from Attorney Crawford, so I have it. Can you send me 923A? I don't know if it's helpful or not, but it's referenced in the notes.
Yes, we are looking for that right now.
Well, that one I was able to pull up. I think that's pretty much the remainder of the standard, or at least the instruction that was used in this case as well. So. Yeah, they sent that to me. So when looking at the elements that the state has to prove, of course, the first one, as I referenced earlier, is the defendant caused the death of Lynn Hernan. There is a definition of cause that's provided, and then the second element is that the defendant acted with the intent to kill Lynn Hernan, and then intent to kill is further defined. I agree and would acknowledge that the phrase practically certain is not something that's defined further in the jury instructions or really in any case that I could find other than that federal case, which I really haven't had I don't know if anyone else has read it. It is a civil case, so my gut says it's distinguishable. There's a different burden of proof. There's an example given in the jury instructions for, I guess, why that language is included. It's to really broaden the definition of intent, meaning there's more than one way. The example given, as you read, was the arson case where the arsonist has the intent to burn a building down perhaps hopes that everyone escapes, but if someone doesn't and dies, that is where that language would be included, and a jury could find intent to kill, because in that scenario, even though the intent was to burning a building down with people in it, that conduct would be practically certain to cause the death of another human being. Now, how I respond to this to the jury, I think, is to simply say the jury, and I'm kind of on free flow thought here, but something to the effect of, the jury must rely upon the definition of the elements of the crime that has already been provided to them. No further definition or explanation of practically certain will be provided to them. Any objection from the state to that?
No, Your Honor.
How about from the defense?
No, that sounds good.
All right, I'll work with Madam Reporter to read back off the record what I just said, so I get that down verbatim. I'll certainly write it out, show the parties. I believe we may have another question coming out shortly as well, so it is right next to me, so don't go anywhere. So this one has a time of 6:08. So this one is in respect to count 2, if the jury find that money was stolen but the amount was under $100,000, do we still deliver a guilty verdict but then answer no to the follow-up question? This is one that I've actually thought about ahead of time, and I think we may need to, if they answer no, then the jury should be asked, was the value greater than $10,000 but less than $100,000, since it's really, we all know that the purpose behind asking that is the classification of felony for sentencing purposes, if there is a conviction. And I think I will have Madam Clerk work on another verdict form with instructions that answers this question with the consent of the parties.
Why do we have to? Because the question is either it's under 100 or it's over 100, right, Judge?
Well, no, the special verdict question says answer only if you find the defendant guilty. So I would refer back to only answer the special verdict question if you find the defendant guilty of count 2.
What's the special question again? Could you read it
It has
out
to do
loud?
with the value. It is.
I know that. I'd like to just know how it was phrased.
Sure. It is in the jury instructions that you have as well, and the verdicts that were emailed, but it will say as follows. That's okay.
I guess we could put the 3 options in there. Was the value more than 100? Was the value more than 10,000? Was the value more than 2,500?
So the specific question in count 2 is, if you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $100,000?
That's what she's been charged with, right? Over 100.
Correct. I don't think a no answer to that precludes them from answering a follow-up question, which was the property stolen more than $10,000. Obviously, that is something that would concern the court at the time of sentencing, and I'm going to need to know that, and I think the defendant has a right to have that special verdict answered by the jury unanimously, and not for the court to decide later on.
Thank you. When I'm looking though at the pattern instruction for 1441, there's you know, on the special question, they offer 4 options to the jury and the pattern instruction. Was the value more than 100,000? Yes or no? Was the value more than 10,000? Yes or no? Was the value more than 5,000? Yes or no? Was the value stolen more than 2,500? I mean, I think if you're going to make other options, then they should be offered all 4, because
I thought about that too.
the class changes.
Correct.
Right.
What's the state's position?
I think that's probably best to just include all the classification levels in the question, and that probably avoids other questions going forward.
All right, let me work on that. That'll take a little bit of time with Madam Clerk. I do want to answer the question, though. That first reminds them I just wonder if the original question should have been theft of movable property as charged in count 2 and then the special verdict, but be that as it may, that's not how it went. So I understand why the jury is asking that, since they're just look, what's, give me that, I think you gave me that number, that was 1441. I want to look at something for a second. So here's what I'm thinking. The elements of theft themselves do not include value, but value is a special verdict question. So I want...
Standard instruction.
I'm sorry?
It's part of the standard instruction, 1441.
What is part of?
The determining value.
No, I agree with you, but it's a special verdict question on value. It doesn't alter the elements of theft. The value the amount alleged affects the penalty. So it may not have been completely correct to include value in the verdict question to begin with, is what I'm saying. In when the verdict read, although I would note everyone agreed, but that the verdict should probably have simply read, "We, the jury, find the defendant, Jessy R. Kurczewski, not guilty of theft as charged in count 2. So there's the not guilty and the guilty, and then if you find the defendant guilty, answer the following question, yes or no, was the property stolen more than $100,000? Now, that's not what we did, but
I see it as pretty significant, because if we are at the lower value, it's a misdemeanor. So I mean, it's a significant difference.
oh, I agree with you, and I
Okay.
feel very strongly the jury needs to tell us what value they put on it. And I think if we're gonna do this for count 2, we might as well do it for count 3, even if they didn't ask. And what I'm thinking of is taking out the value in the guilty and not guilty parts and have the 4 questions as to both with agreement of the parties. So kind of show them that.
They have to be 2 separate values, one for each count, right?
Correct.
Okay.
Just include all 4 questions and say please see the revised verdict forms with agreement of both parties. Yeah, I only have one at the moment.
That you're proposing to change the verdict to actually change language in the upper part of the verdict. And I would have a problem with that.
This is what the state's requesting, Your Honor. This is actually what the elements are of the crime charged and then the special question afterwards. If they agree and fill out that verdict form, they'd be finding her guilty of theft, just plain and simple, and then they would answer the valuation question. I think that's appropriate.
It still says as charged in count 2. And so that's
Yes.
the reference. I don't have a strong preference either way. You could leave it in with the 100,000. You could leave in the 10 to 100 and leave the questions. We might be back here with some more questions, but I think when you really break down what the elements of theft are, value is important because, as you said, it could be more, could be less, and if it's substantially less, it could even be a different classification of charge altogether. So,
I mean, I agree with adding those special questions at the bottom. I don't agree with changing the body of the original verdict.
well, I think we had that in there originally, and we might have to live with that and see what the jury does, but I think this will help clarify that for them, and we'll see. So I need to work on how I want to draft the responses to them. I'll do that. I'll make sure the parties see that first before we send them back. Let me go off the record, and Madam Reporter, I need that language for the first one. You're- On the record, then, I worked with the parties at sidebar. It's not technically a sidebar. I had Madam Reporter working on getting me what I said about the first question that we were addressing. And that was, may we please have a definition and elaboration on the term, quote, practically certain, listed in the second element under count 1. My response, based upon our discussion earlier and confirmed by Michelle, the court reporter, I tweaked it just ever so slightly, but I thought this read a little better, is as follows. The jury must rely upon the definitions provided in the jury instructions. No further definition or explanation of, quote, practically certain will be provided. And that's my initials, 6:37 p.m. And then the verdict forms, Madam, where are those? Right. Oh. And I just wrote out in response, you can, hold on, I'll break everything together. The following verdict forms are being submitted to you on counts 2 and 3. Please use these sets rather than the ones originally provided. And again, there's a not guilty on top of a guilty for count 2, a not guilty on top of a guilty for count 3. And then for both charges, we put the various valuation special verdict questions so that they are not just given 1 or 2, but all 4 under the statute. And that's with the approval, both things from the state?
Yes.
And from the defense?
Yes.
Okay, then we'll make sure these go back. And then Madam Clerk and I, if you would go take those back, please. There are more exhibits that are being requested. Haven't had an opportunity yet to pull them. But first exhibit listed is 501. That's a lab report. 619. Which is a demonstrative exhibit used by Ms. Eisenhart, and that's the handwriting analyst. Somewhat funny, as we were joking, not really at sidebar, how I can't look at my handwriting anymore and not think of her testimony, so it seems to be fitting. In addition, 522, which is part of item 20 from the handwriting. I don't know what 64 is, but then 503 to 508 and 515 to 519, those are all portions of the handwriting. I don't know if it was everything requested. Anyone have, I'll have to look at my notes, was 64 something that was marked maybe for identification?
No, we never talked it or referred to it in the trial, so I'm not sure.
All right. Any objection to any of the exhibits requested, other than, of course, I'll let them know 64 was not an exhibit used in the trial? From the state?
No objection from the state.
No objection. Could I have a copy of that note?
Yep, we'll get that momentarily. I'll actually write my response and then, actually just
I
copy
just
it.
would like
so
to
it's
take a
easier.
look to make sure that I agree it says 64 on there.
I'm gonna give it to you.
Okay.
Okay. I'll just tell you what they are, go down there. Oh, that's hers. 501 is her, I believe.
It starts with 503 though, right? I marked that by accident, I think.
No, it starts with 501.
Okay.
This is a lot of the handwriting stuff. So 501 is her report. 50. And then starting with 503 to 508. Skipping 511, and then 515 to 519. actually including 522.
Wait 1 second, no, not there.
Sorry.
That's all right.
Are you on 15?
11.
11? No 511. They did not ask for
Not
511.
12, right?
There is no 12.
13. Yeah, I didn't get to pull out all the extras in here yet.
15, 16, 17, 18, 19, 22,
17, 18, 19. Okay, I have to 19.
22,
So not 20. 22.
and then 619, which is her demonstrative. It was that real shiny PowerPoint with a lot of blue, if I recall.
So just to make sure I have them, we start with 501, 3, 4, 5, 6, 7, 8, 9. You said 9, right?
Yeah, no, 509.
No 509?
Oh, 509.
Good, certainly. And then we jump to 515,
Yes.
16, 17, 18, 19, 522, and 619.
Yes. So my response, I'll just read it because it's very simple. 64 is not an exhibit. All other exhibits are attached. Approval of the state?
Yes.
Approval of the defense?
Yes.
All right. 6:44 p.m. on that. There you go. And then here's this one. You should have all of them.
Yeah, I have them.
Is that already good? You went back. Oh, that's just
Yeah,
a
that's why I
copy.
had to make a copy right away, just so we wouldn't get
Got it.
lost.
All right, we are in recess then. Thank you, everyone.
Thank you.
back on the record. Appearances are as they were before. At about 7:20, we were notified that the jury is tired and they'd like to break for the night. So I assembled everyone here. The jury will be brought out, including the alternates who have been on a separate floor, so I can read a modified instruction 50 with them. Hopefully Jen was communicating with them, but yeah, go ahead. Have them all brought in. While we're still waiting, there's some logistical issues, and so we're gonna have the jury brought in at 9 a.m. tomorrow. Have them report at 9. There's a couple of other juries. This morning, some of their parking spots were taken, so I wanna make sure that they're taken care of, and they've been here late, so. There's a couple other juries that are starting tomorrow, so there's some logistical issues with civilian bailiffs, deputy bailiffs, so it will be smoother if we have them come at 9.
All rise for the jury.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, I know we have our 3 alternates as well, but since you will all be now, minus the 3, stopping your deliberations for the evening, it's important that I read to you, at least modified from the original instruction that you've heard me read multiple times, but you may not continue your deliberations once you are outside that jury room. Do not discuss this case with anyone else. This is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public record of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home this evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules,